The Rivers State government has formally appealed the Federal High Court Abuja's judgment restricting Central Bank of Nigeria allocations from the Federation account on Wednesday. Now, with Information and Communications Commissioner Joseph Johnson expressing confidence in securing a reversal at the appeal court. How has this affected life in Rivers State? By that I mean the running of government. And indeed, can it affect the running of government in Rivers State? And what's next for Governor Sim Fubara and the people of the all-rich rivers? This is the Eastern Eye. I'm Alex Obodo. You're welcome to the Eastern Eye here on Afia TV. It's a program that x-rays the political, social, and economic developments around us. Tonight I'm joined from Port Harcourt, Rivers State by Tony Ekine. He's a lawyer and human rights activist. Good evening to you, Barrister Ekine. Thank you for joining me tonight on the Eastern Eye.
Thank you for having me. It's my pleasure.
So the first question will be, how is the Rivers State government taking that particular judgment that came out of Abuja on Wednesday?
Well, as much as I'm not the spokesperson of the Rivers State government, but I watched a state event yesterday when the Rivers State government organized a Thanksgiving, and I heard and I watched when the governor was calm and enjoined every Rivers indigene and resident to be calm and not to worry much about that judgment of Honorable Justice Joyce of the Federal High Court yesterday. Telling Rivers people that isn't the biggest problem, that's even less of a problem as much. But I think that in my view, Rivers State has continued to be calm. Rivers residents and indigenes have continued to be calm since October of last year. However, concerned about the political developments and how these unnecessary, avoidable crises affects administration in Rivers State. But I think thanks to God that the governor of Rivers State and his team have been able to stand fast and stand strong in this trying moment. Administration is going on in Rivers State. Projects are going on in Rivers State. Civil servants are going to work, and meaning that they are receiving their entitled remuneration and salaries. Government functionaries are working. And I think that the Rivers State is calm. I live in Port Harcourt. We go to work, we come back. I'm having this conversation with you right from my home. I haven't returned from work. And that applies to everyone who is resident here. So I think that the judgment of Honorable Justice Joyce is one of the many judgments that have come with the issues that have arisen since October last year. That is the crisis in the Rivers State legislature. We do know that our executive arm of government has no problem. The time the governor had his own issues that arose from the elections, 2023, was when he had matters before the tribunal. He got to the Court of Appeal and to the Supreme Court. So that is over. The judiciary in Rivers State is functional. I was in court today. I think it's in the legislature that we have one Rivers State House of Assembly, but I think what is happening there is contestation about the leadership of the House, and then the vacancy that has occurred arising from the willful defection by a whopping 27 members of the Rivers State House of Assembly. In my study of political science and law, I haven't come across anywhere in the world that kind of cross-carpeting in any legislature in that number. And then not even in the history of political development in Nigeria that we have had that number of cross-carpeting in any legislative house. So it appears to be a new thing, and that's why it's been the talking point since October last year and now 1 year, because this is novel. But we must continue to uphold the provisions of our Constitution, which we all have obligation to perform as citizens of the Federal Republic of Nigeria, as authorities and even institutions of government. Everybody has a duty and a responsibility, particularly even those who have taken to an oath sworn to uphold the provisions of the Constitution. And that is why the provisions of the Constitution of the Federal Republic of Nigeria, particularly Section 109, subsection 1, paragraph G, has got to be given effect as provided in the Constitution and in line with the intendments of the drafters of our Constitution.
I mean, thank you for at least providing a perspective of what is going on out there in Rivers State, especially in Port Harcourt. But then let's bring it to the real actors of this issue. Everyone believes that the reason why Rivers State is having a problem is a purely political issue. And but some people are in denial that it isn't political. But the question is the timeline for a political solution running out in this? Because if at the moment there's a case in court to cut off oxygen from the people of Rivers, because technically this is what it is, if you don't get your allocation, nobody will be paid. So technically, if the oxygen that comes to the state is cut off, what will be the fate of the people? Is this really an indication that a political solution or a timeline for a political solution might be running out?
I think I've had a response at some point where I'd argued and made a submission that there is nothing like political solution when constitutional matters are rife. That is to say, when certain issues are clearly, with respect to provisions of the Constitution, and the extant provisions of the Constitution are unambiguous, I think it's only when a society clearly acts in a way that undermines the principle of the rule of law, which is the predominance of the law and nothing more pretentious, no arbitrariness whatsoever, but the predominance and supremacy of the law. So it's only in a society such as ours where we undermine that principle of rule of law that we would talk about political solution when there are contraventions of provisions of the Constitution and even disobedience of orders of court or decisions of court. And let me lay this clearly what I mean. The Constitution of the Federal Republic of Nigeria remains a grundum. And then, of course, there wouldn't be any alternative, not even discretion of Mr. President, let alone political maneuvering or any political consideration. It is the law as it is with respect to the Constitution, when it comes to the Constitution. Otherwise, we will be joking. Then again, decisions of the court, particularly the apex court, the Supreme Court of the Federal Republic of Nigeria really, has given clear decisions with respect to the very remote causes of all of these avoidable crises in Rivers State. And that is, the Supreme Court has given interpretation to the effect of defection in the circumstance that does not satisfy the proviso to section 109, subsection 1, paragraph G, because clearly it's automatic. Once a legislator defects and becomes a member of another political party other than the political party that sponsored him to office, don't forget that in our Constitution today, being sponsored by a political party is one of the qualifications to run election into elective position as created in the Constitution. We don't have independent candidates yet. And that is why once you are elected and sponsored to a legislative house by a political party, and you denounce that political party and declare to be a member of another political party, you lose your seat. The only proviso is to the effect where there is that clear division or splittering in that political party or a merger with that political party that sponsored you and another. Now, the Supreme Court has given a clear description or definition of what that division or splittering will mean. So it's only in a circumstance where that exists that a defection will be justified. And in this circumstance, it doesn't. So the reasoning of a political solution in this regard, like when an attempt was made sometime last year that the president intervened and then gave some directives, we argued that that directive wasn't enforceable and cannot take the place of the provisions of the Constitution. You cannot take away the powers of a governor to appoint his commissioners as extant in the Constitution, vesting exclusive powers in the governor. But we had a situation where there were directives to the governor as to who to reappoint or to absorb as a commissioner. For instance, you also cannot have any political arrangement that would take away the constitutional power of a governor to lay appropriation bill before a House of Assembly. There is only one House of Assembly that is established for each of the 36 states in the Federation. and the River State House of Assembly is one. So when a governor who is not a member of the House of Assembly and cannot be a party to whatever disputation as to the leadership of the House of Assembly has his appropriation bill to lay in the House of Assembly, haven't considered that bill at cabinet, he writes to the House of Assembly. And then the House of Assembly invites him and he goes there and he lays his bill. And the number of legislators that are there for him is what constitutes the membership of the House. And he's not living outside of River State. He's a member of the state, he's resident in the state, and of course the chief executive of the state. So he knew that 27 members out of 31 that were left, having lost one, were no longer members of the House. So he had the House and he presented. But today, you would hear Nigerian judges and judiciary, with respect to our judges, with very huge, enormous respect to the judges. But then decisions come up.
Are you still there, Mr. Kine?
You lay appropriation bill before 4 persons. Why wouldn't you lay appropriation bill before 4 persons when it is not the intention of the drafters of our constitution? It's an unfortunate situation. Nobody envisaged this. Nobody in River State is happy that we have a House of Assembly that are so depleted from 32 to 4. In the first instance, it was natural because one person died. But in the second instance, willfully, to their own right, 27 members walked away. So the River State House of Assembly must continue. And there were 4 members who had no inhibition at all because they are still members of the House. They haven't resigned. They didn't die. They are not taken into any executive appointment. All of those constitutional provisions that would create vacancy in the House of Assembly did not apply to these 4. So arguably, and in the eyes of the law, they were the only members left. It's unfortunate, no doubt. But emotions will not take the place of the provisions of the Constitution. Where some are saying, oh, how can 4 persons legislate for the entire state? It wasn't their intention to be 4 to legislate. And that was why I recall that when this happened, when the 4 members that were left elected for themselves a speaker in Edison a year, and at that point, the governor laid the appropriation bill before them. After the passage of the appropriation bill, they quickly adjourned. In fact, rather, when they declared the seats vacant, they quickly wrote to INEC, directing INEC, or rather requesting INEC to conduct election as required by the Constitution within 90 days. And they adjourned sine die. That long adjournment was to create room for INEC to conduct the election so that all the constituencies would have been represented for them to return for proper legislative business. But INEC didn't do that. Persons began to go to court, sought orders, and the court granted orders to restrain INEC to perform their constitutional duty. This is problem. It's threatening democracy that the courts made orders to restrain a constitutional body, INEC created under Section 153 of the Constitution, to perform statutory and constitutional functions. Then courts will say, oh, don't perform your constitutional functions. So what will happen? That vacuum was created by people who willfully did so, and it remained. But River State must continue. You cannot hold a state as prominent as River State in the Committee of States in this country to ransom by the discretion of some individuals or the manipulations of politicians. And then we talk about political solution. It should be constitutional solution. It should be legal solution. It should be judicial solution, not political solution. It was created and orchestrated by politicians.
There lies the confusion, Mr. Kine, there lies the confusion. The problem was created by politicians. So meaning that the moment they decide that the problem will end, it will end, irrespective of how many cases are in court. I mean, one can just tell his lawyer this night to withdraw all the cases, and all the problems will go away, isn't it? So, indeed, there is a possibility of a political solution. And the question is, why are we not making a move, or why does it appear that the big players and the political crisis in River State seem to have thrown away the possibility of a political solution? Or is the bullying too much for anyone to take a step back and say, okay, let's shoot the swords?
Okay, if your assertion is what you mean by political solution, then in a way, arguably, yes, but you would agree with me that even your assertion will end with a judicial solution, because even when the politicians make the decision to say, look, we are going to withdraw our suits, it will still get back to the court. So it's a judicial solution, where so it's a mix, a hybrid, or perhaps political and judicial solution, where, okay, yes, the politicians can, in their closets, decide to discontinue a suit, and that's correct. I can tell you, and I can report here today, that there was a move in that direction in a suit that I was in court today before the Federal High Court. And then, yes, some aggrieved members of a political party filed a suit, and then in some way, the same political party, they agreed and resolved whatever differences there were within that political party. And then the plaintiffs who filed that suit filed their notice of discontinuance today. And then I've always said this, that discontinuing a matter is like a snap of the fingers. And then all the judge needed to do was to confirm that the notice that was filed has been served on the other counsel and the other parties. And with that concurrence and the fact that there were no objections, the matter was struck out. But it still got to get back to the court and then judicial. But fundamentally for me, my concern and worry as a constitutional lawyer is that when we begin to undermine our extant constitutional provisions and give credence more to politicians and political solutions or maneuverings, then we are seriously in a problem, especially in a constitutional democracy, where the bedrock of our democracy is actually the rule of law, and then the provisions of the Constitution become the strongest pillar, even in that principle of rule of law. So, but in any case, I would agree that the day that the political gladiators in Rivers State wake up to the reality that, look, they should have conscience, and then whatever they are doing to their selfish interests affect the greater proportion of the population of the state, both indigents and residents, and then shift their swords, then I think that we'll be getting really fast close to the end to all of these unnecessary and avoidable and orchestrated political crises indeed.
All right, let's go back to the judgment of the Abuja High Court on Wednesday, which is, of course, has ordered the stoppage of the allocations to Rivers State, ordering the CBN to stop giving them their money. Of course, obviously, Rivers State government has appealed that case. But then I'm aware that there are other litigations here and there regarding the legality of whether the people that defected are still members or not. So where do we find ourselves? By that, I mean Nigerians, watching what is unfolding in Rivers State. There has been instances in the past where there have been judgments regarding state resources versus what the federal government thinks. You know, the case between Lagos State and the Federation of Nigeria, of course, it's called now, it's just the attorney generals that represent their states and the federal government. So I think it was 2005. Lagos State Attorney General and Attorney General of the Federation regarding the local government funds for that period when Tinubu was governor of Lagos State. But there is a distinction between the two cases because obviously the case did not originate because there was a problem in the House of Assembly. This particular case is coming to the forefront because there's been a disagreement between politicians, which has trickled down to their followers who are making the whole thing even more difficult. Do you see a situation where a very interesting judgment will take place and then it becomes a precedent? You suspected that an interesting judgment is in the offing. We are not trying to preempt any court of competent jurisdiction. But from what we've seen in the last 1 year in Nigeria, anything is possible, isn't it?
Yes, it does appear that anything is possible in Nigeria. What is not possible in Nigeria can be possible anywhere in the world. Some say as a street palace. But then I think more seriously on these issues, the political and judicial developments in Rivers State lately, I think will in some form shape the democratic landscape in this country, if you like, the way our democracy is headed. Unfortunately, the democratic ideals that I have come across and I have come to know, and I thought that Nigeria professing to be a democratic society should apply, appear to be eroding as fast in this context. Yes, I would agree that in a way, the decisions of the courts that appear to be multi-decisions that actually are, and then even litigations, like you stated, in different courts with respect to all of these matters are actually going to get to the end. And I desire in some of these cases to get to the Supreme Court so that we have a direction, what could be like a policy or a review of the laws, and even probably may lead to some amendment or alteration of some provisions of our Constitution. So if you consider the multiple litigations in the courts, for me, actually, those are politically motivated, no doubt. There has been a lot of forum shopping that got to this filing of multiple cases on this same subject. But what's important is what the judiciary would do standing upright and ensuring that what is proper is done. That's for me what's important. And that's to put a test on the judiciary, which of course we also hold as the bedrock of democracy. And then of course to ensure that the laws are interpreted in the ways that they ought to be interpreted. So I expect that the cases in the trial courts, those that are subsisting in the trial court, without making an attempt to get into the merit of those cases, will get to a point where they will get to the Court of Appeal and probably get to the Supreme Court. Some of which have got to the Court of Appeal already. Those who are dissatisfied have filed their appeals further to the Supreme Court. So I would expect that the Supreme Court will again have an opportunity to decide on a matter. But my worry is that on a matter that the Supreme Court already decided, the Supreme Court has been very clear as to the effect of defection in the context as it had happened in Rivers State. The Supreme Court has been very clear as to the effect of or the decision with respect to stopping, restraining the allocation of funds to any tier of the federating units in this country. You made reference to the situation in Lagos. In Lagos State, it was about local government, which is the third tier of our federal system. I think in the case of Rivers State, it's even going to be the first time in the political history and development of this country that a state will be restrained by the courts from receiving allocation. I would even talk about the implication of that, because the case you asked to distinguish, the case in Lagos wasn't about allocation to Lagos State. So one would imagine that Lagos State government was receiving the allocation that was, if you like, into the credit of the Consolidated Revenue Fund of the state.
That's right. Because
it was a different case that relates to local government. But in the case of Rivers State today, yesterday, is one that seeks to restrain allocation to the state. And by implication, it means that the state should be grounded. A situation where a governor who probably is handicapped could find himself addressing the state and then declaring a shutdown of the state, of governance or administration for such a period that perhaps those who are going to enforce this will have conscience to determine which way to go. But why would we get here? And then what is the issue we had discussed when we're talking about the situation in Rivers State House of Assembly? Because the judge, with respect to Honorable Justice Joyce, premised this decision fundamentally on the issue of the laying of the appropriation bill before the Rivers State House of Assembly. So if that's it, then we have to really be pragmatic and then be decisive and know that we've got to the point where there must be a clear pronouncement with the issue of defection of the 27 former lawmakers in the Rivers State House of Assembly and the consequence, the effect of that defection. Because if that had been decided, we would have got to a point where the court will restrain the central bank and then other agencies and authorities of government from releasing allocations that are due to the state. But let me also say one thing here, which is very fundamental. We have forgotten that the courts have also held that the funds to the credit of the federation account or the Consolidated Revenue Fund of the Federation belong to the three tiers of the of our federation. The funds there do not belong to the federal government. It is elementary for all of those who are watching us to understand that even when the state declares a certain amount available for appropriation or for distribution among the tiers of government, the federal government has its share. So the federal government can only deal with its share, determining who gets what, when, and how. They cannot get to determine what happens to the funds that belong to a state, because there is another share for the state. The same way that is a share to the local government. But right now we have a situation where we are dealing with the funds that belong to a state.
That's right.
And then some individual, regrettably, someone from River State would want to go to a court and say, starve my state of funds and ground my state from functioning.
I like the angle you've taken this, and we'll expand on it when we return from the break, because you talked about the Constitution and how clear the Constitution is regarding the movement of funds between the states and the federal government. So when we return, you help us get some clarity on that constitutional provision and how it would be that someone or some people from Rivers are comfortable that the oxygen per se, this is using this as a kind of a way to describe it, they are comfortable cutting off the oxygen to River State in terms of their resources. That's when we return on the Eastern Eye. Stay with us. You're welcome back to the Eastern Eye here on Afia TV. It's a program that x-rays the political, social, and economic developments around us. My name is Alex Obodo, and I'm still talking with Barrister Tony Ekine. He's a lawyer and, of course, a human rights activist. Thank you so much, Mr. Ekine, for joining me from Port Harcourt. So the question is...
Very much. Actually, Henry Ekine.
I'm so sorry. I don't know where the Tony is coming from. I don't know. I must have spoken with a Tony before I came on air. Okay, so a lot of people don't have the clarity regarding the powers the federal government may possess in discontinuing allocation to any state. The point you are making is that it's not that simple for the federal government to discontinue any allocation to a particular state. But is it going to happen now if a court says so in Nigeria? I mean, if the House of Assembly or some members of the House of Assembly claim that because of an illegality in presenting a bill, that the appropriation bill was this and it was that because of that, you can't get your allocation. How does that really make the whole thing about being in a federation look?
Yes, thank you. I think I was surprised where that would have come from, because it is not a constitutional provision that is consequence of failure to lay appropriation law before a legislative house is to withhold the funds or the entitlement allocation to any state. It is not in any provision of the Constitution of the Federal Republic of Nigeria. It is also not in any statute in this country. As a matter of fact, it's even in disobedience to the decision of the Supreme Court. You recall that when we started, you made reference to the situation in Lagos, which of course was with respect to local government, sometime 2004, 2005. And the Supreme Court was very clear in that regard, that there was no reason, and it was unlawful, unconstitutional. It was not justified to withhold funds that are credible to any tier of government. That was the local government, let alone the state. So if there was any infraction to the provisions of section 120 or 121 or 122, as the case may be, with respect to appropriation of public funds, with respect to preparation of appropriation bill and laying before the legislative house, and then with respect to the passage of appropriation bill into law, there is no provision, to the best of my knowledge, in any section of those sections or subsection of those sections in the Constitution that will be clear to the effect that the consequence is to order the withholding of allocation to a state. What I know in the Constitution is that a governor can even continue to direct the withdrawal of funds from the consolidated revenue fund of a state. And let me dare say even that the consolidated revenue fund of a state will receive and hold funds that are credible to the state, whether from the federation account or from internally generated revenue or other sources of revenue. So the governor of a state has the power vested in that governor in the absence of an appropriation law to even authorize withdrawals from that fund up to a window of about 6 months into a financial year. So even in the event that an appropriation bill wasn't presented or laid before a legislative house, or if it was laid and for whatever reason it wasn't passed, to the effect that there is no appropriation law at the beginning of a financial year, because, and that's the matter here, because it wasn't intended that at any time the government of a state should be grounded. By reason of cutting off the oxygen, I would want to adopt your analogy here. And that was why that the Constitution and the drafters emphasized that for whatever reason that an appropriation bill cannot be passed, that the government of a state should continue, so that the governor can even continue to direct the withdrawal of funds to be able to run government. Not exceed the amount that was appropriated in the previous financial year. So how then would we get to the point where we will justify that we will even, by an order of court, with respect to the decision in this case, because it remains valid until it is overturned by an appellate court, that we will have a situation where a state or any level of government in that regard, in our federation, should be denied of funds, denied of administration or governance. Look at the practicality of this. Where a state is denied access to fund, it will mean that, assuming that there was no other means of revenue in any particular month, or even if there was, and then the state had some savings that may be able to run government in 1 month or in another month, to pay salaries of public servants or civil servants, to provide subventions and, if you like, contingencies for agencies and parastatals and departments of government to run daily, then what will happen if the state runs out of that reserve? Or what will happen if the state never even had a reserve, but was going to depend on that monthly allocation to be able to distribute when it comes? It will mean practically, this one you don't have to, it's not a thing that Nigerians will pray about, that let us pray the way we do. The practical reality is that when that state runs out of oxygen, the state will die. When a living organism or a living, runs out of oxygen, that living organism will die. So if a state runs out of fund, there can't be administration. And look at the practical realities here. If it is immunization, in a short while, there can't be immunization again for children in that state or in that local government. Because assuming that funds will be made available to the store of vaccines in a primary health care center or department, and then that store of vaccines will have to be regulated in terms of the temperature to keep vaccines effective and functional. And to do so in a country where there is no steady power, you're running a private generator with diesel. And then to get that diesel, you have to have subventions monthly, overhead costs, so to speak. And then it's not available. It means that the diesel won't be available. It means that that plant will be on, and it means that the vaccines that are stored there will go back. Or when they finish, you won't have another one to be able to immunize children. That's that.
Okay.
Pregnant women will be able to access public health centers for antenatal.
All right.
Primary school can't run because children won't go to school, where you won't have the subventions to be able to provide writing materials, chalks, or to run daily cost of these public schools. Let alone even not able to pay salaries for workers, teachers, health workers, civil servants, and everybody that works for government. It's not about the governor.
All right. So
it's not about politicians.
Now that you mentioned the governor, Mr. Henry Ekine, there's something we've been seeing online in the last few hours as to what seemed to be an action by the governor of River State. I'm not sure whether you've seen it. Maybe you have. Just help us to tell us exactly what the situation is in River State. The governor ordered a shutdown of NNPC and other oil companies running in River State. Is that correct? I've been seeing this. This been circulated online.
Not aware yet. I'm not aware yet. And whether the governor has the power to order a shutdown of the NNPCL, I don't know. First, where that power will derive from any of our laws. Then, but to even say here whether I can't confirm, I'm not aware of such order yet.
So, I mean, typically, if the governor was going to make that statement, those in River State would have heard it first, isn't it? And you are in Port Harcourt, and you are confirming that you haven't heard such. So, in essence, I haven't heard yet. So, in essence, this could be a figment of somebody's imagination. But is this scenario possible, really, for a shutdown of the oil installations in response to, if you cut my oxygen, I'll cut the oil that gives everybody that oxygen? Could this be a potential measure for measure, tit for tat situation if push comes to shove?
Yes, I think that should also be a concern of our administrators and then everybody who has the concern for the progress of this country. Yes, there could be that potential reaction. Like I said here, that the effect of that judgment isn't about Mr. Governor or his cabinet or even politicians, but about the people. If it is properly interpreted and communicated to the people, and don't undermine Nigerians. Nigerians are highly intelligent, we are highly informed, highly knowledgeable, and then of high sense of interpretation. Forget the deliberate misconstruction and if you like, maneuvering of politicians. Nigerians are quite aware. So those in River State are not excluded, and then even those residents here. So residents in River State understanding the effect of this on them, it's possible that we say, oh, and don't forget again, the greater proportion of what will come to the Federation account that will come before the committee for distribution arguably comes even from the proceeds from oil and gas. And this is one of the states that is highest in the ranking of production of oil and gas. And then so it is only natural that people will say, oh, our money and what's...
Are you still there, Mr. Henry?
Them, and okay. Then now we will not get, even if it is kept in escrow account, but we will not get it. I don't want to preempt whatever will happen so that I won't be held to be said to be inciting, but I have heard those feelers. I think at some point I even heard that there were threats that some individuals have said, oh, if this happened, that was even before now, when it was threatened that allocation should not go to the local governments because of caretaker committee arrangement. There were threats that, look, if that happened, because these local governments are actually where you even had these oil installations, that they were not going to be sure that those installations will be functional. So I'm afraid that we need to do something about it, really. And the government has to be very circumspect in some of these regards and in some of these actions that we will take. Right. I recall sometime during Yar'Adua's administration, there were issues that led to a serious depletion of our production in oil, in crude oil, that it got to less than 600,000 barrels per day. And that was quite disturbing until it get to the point where the federal government had to intervene. That led to the amnesty program. And then of course, that led to a solution that shored up the production to a reasonable level of over 1.2 million barrels per day, and then it rose again. But we have to be sensitive to some of these issues, really, when we do things in this country.
We have about
do not let the politicians to get us to a point where everybody will suffer more than their own political interest.
Great. We have about 3 minutes to go, and it will be rather odd if the name of FCT Minister Nyesom Wike did not come up in this conversation. And everyone, or a lot of people, believe that he is at the center of this crisis. He hasn't pointedly owned up to that, but his interviews are laced with anecdotes and pointers to the fact that I know they agree for anybody. it's a using a pidgin language there. He still has that stance of I know they agree for anybody. I mean, if this continues, I mean, because a lot of people are saying that he's been governor for 8 years, and his own stance, he didn't give anybody any opportunity to displace him even an inch in Rivers State. How long can this go on? We have about 2 minutes. How long can FCT Minister Nyesom Wike hold on in doing this if he's the one behind it? And how long can Governor Sim Fubara, continue to also be like this? 2 minutes. Hello, Barrister Akine, are you still there? We seem to have, his network is frozen out, and unfortunately, the biggest question goes up in flames, maybe. I don't know whether we'll have the opportunity of reconnecting with him, but whatever happens, I guess Nigerians will continue to watch out and see what becomes of the political crisis in Rivers State. I don't know whether Mr. Akine is back. All right, and that will be that for the Eastern Eye for tonight. I have to thank him immensely. Mr. Henry Akine is a lawyer and human rights activist. He joined us from Port Harcourt, Rivers State. And that's the Eastern Eye for tonight. Of course, remember that the IFA TV will be having an all-day coverage of the Abia local government elections on Saturday. It's just 2 days away. And do join us from 8 a.m. on Saturday for coverage of that election in Abia State. Up next is Nka with Juma Bulama Ashebu. My name is Alex Obodo. Good night.